Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I'm a divorce valuation and mediation expert in St. Louis, Missouri. I have the pleasure of discussing today a fabulous book called the Forensic Accounting Deskbook with my guest, Miles Mason, a divorce lawyer in Memphis, Tennessee. So he's actually written this book, the Forensic Accounting Deskbook, and it's a practical guide to financial investigation and analysis for family lawyers. But I also think it's a really important resource for business valuation experts. Welcome, Miles. I think you bring up an interesting kind of nuance, right? Because not everybody understands, first of all, not everybody really understands the whole expert witness process. But then beyond that, we have a difference between a testifying expert and a consulting expert, not just in divorce, but in all types of litigation. And maybe you can give us a little bit of knowledge from an attorney's perspective, like what is that difference and does it matter at all?
It can matter, and it has mattered, and it might matter or not. And that's why you have to navigate this and understand, because one of the things for lawyers who don't understand this, they look like idiots in the courtroom. Okay. An expert witness testimony is the time for where the lawyer should shine. Okay. I don't want to say it's easy, but it's kind of easy to do direct examination of a forensic accountant. And if you got somebody else helping you with the cross-examination of the other expert, you're going to look like a genius. You can't help but not look like a genius if you have some training and understanding what's going on. Now, let's put this together. A consulting expert is one that is not anticipated to testify. And if they're not anticipated to testify, they don't have to be disclosed. All right. So if you want somebody to be a consulting expert, as the lawyer, rule one, make sure in the engagement agreement it says consulting expert only. Okay. And I know that because I've been in court and argued when I had a prior business valuation expert that my client had paid for and paid $30,000 for a BV. And some time passed and we wanted to see it. And we had disclosed this expert as our witness. And the other side, no. It was our witness, consulting only. Okay. And I said, okay, where's your engagement agreement that says that? And the other side had no engagement agreement. They probably did, but it probably was a boilerplate. And although I never got the BV, I got my client the $30,000 back, which was almost better because the BV was too old at that point. The divorce had dragged on for quite some time. So you want to dot your I's and cross your T's if you don't want to disclose. And that also applies with forensic psychologists as well. Now, once they testify, I take the position and argue in court that everything that the testifying expert sees, hears, tastes, reads, smells, thinks is discoverable. Now, we've had that recently in one of our cases, and the law may or may not say that in any particular state, but why wouldn't it be that way? And the first stop is, of course, whether it be Missouri or Tennessee, Rule of Civil Procedure 26 is the federal rule that applies and says what information has to be exchanged. Now, one of the subtopics under that, what about email between the expert and the lawyer? Many forensic accountants in seminars say, be careful, you may have to give up your email. I don't know why you wouldn't have to give up your email. But I can tell you, I think the practice nationwide is even if it's subpoenaed, don't give it and make the other side file a specific motion to get the email because they probably don't. won't want to go to that expense, although I like to, because I want to see what's in those emails.
Oh yeah, absolutely. I mean, I think the biggest issue as an expert is if you're going to be a consulting expert, that you treat it as if you are a testifying expert, because it is the same if you convert at any point. So when I come in as a consulting expert, I'm there to look at other reports. I'm there to give some idea to the attorney what to look for, right? Or to talk about strategy of like, you don't have a case, you do have a case, here's the BV, here's the lost profits, whatever. But in the engagement letter, they can convert to a testifying expert. So I tell the clients and the attorney, we're going to operate as if I'm a testifying expert from day one. There will be no email exchange. There will be calls. There will be Zoom here, meetings and things like that, but nothing in writing. I have also had cases where the attorneys have agreed that the emails between the attorney and the expert for both sides, they would not provide. But
Right.
that's an agreement.
And I think that's smart from both sides, because the odds are there's nothing in there that's all that exciting from a substantive standpoint. And whether or not a particular fact is in a forensic accountant's head, the experienced forensic accountant's going to say, well, I discount everything my own client tells me anyway, because I'm an objective, independent witness. And if it's not on a piece of paper that's in the financials, probably not even considering.
Mm-hmm. Well, and I think that, it's more so clients have a harder time totally understanding this process, or maybe new attorneys, new experts. I've seen that that's where people will kind of be like, can you make the number be 2.5 million? And then they end up in court at 2.6 million or 2.4 million. And they're like, well, but this email said that the attorney asked you to be at 2.5. So you're kind of there. I think that those are the types of things. Or I've tried to say, use email for factual information. Like, tell me the date of something, tell me that something exists, but don't say, oh, we need to try to make this be lower by excluding it.
Right.
Sorry.
I've got standard deposition questions I ask in every engagement on what did the lawyer say they hope the valuation turned out to be, and what the client wanted the valuation or the testimony to be. Mm-hmm. And I have 6, 7 in the book, different questions coming at it from different angles to ferret that out. And if I get at a deposition a email or document from the client or the lawyer to the expert that marries up pretty close, I've got great fodder for cross-examination and exhibits for the courtroom.
Mm-hmm. Yeah, because when it comes right down to it, how an expert is most effective and efficient is by supporting their conclusion, which means not from somebody said it's going to be this number or that number. Because I've talked to other attorneys and other experts, and guess what? We can see it. We can see when you've contrived a number. We can see where you made an assumption that is completely out of the realm of reasonableness.